Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And I want to begin by saying good evening to all of our viewers who are joining us on television in Region 5, West Coast Berbice, Mahaika to West Coast Berbice. Welcome to another program of Issues in the News. Across the Berbice River, on the east bank of the Berbice River, all the way to New Amsterdam, Quarantine Coast, and further down, all of you who are joining us on television in those two great regions of Guyana, regions 5 and 6. Welcome to another program of Issues in the News. To our viewers and listeners who are joining us on Freedom Radio on Rob Street, Georgetown, welcome to another program of Issues in the News. And last but not least, to the thousands of you who are joining us on Facebook Live across Guyana, the Caribbean, North America, Europe, Asia, and even further afield. Welcome to another program of Issues in the News. Please share this program. Press that share button on your phone. Share the program so that as many of your followers and friends and those who are on your page and who have access to your account can join us in this live broadcast. Once again, please share this program so that we can have the widest audience possible. I see many of you have joined us. Vasudev Singh, Naimoon Ahmad, Paul Perez, Winston Kublal, Alex Prasad, Rajendra Singh, Indar Singh, Shamu Gir, Omar Khan, and so many of you. Frank Badrinarayan from Toronto, Brampton, Ontario, Betty Chris, Rajesh Siraj, and all of you. Press that share button on your phone, share this live, share this program so that as many of us as possible can join in tonight's discussion. I want to dedicate tonight's program to giving an update on some important matters within the purview of the Ministry of Legal Affairs and Attorney General Chambers. So most of the program I'll dedicate to some important developments taking place under the supervision of the Ministry of Legal Affairs and Attorney General Chambers. But before I get there, permit me to comment on the ruling of the full court in dismissing an appeal filed by the Attorney General in relation to the BK Marine matter. That is a case involving a wharf at Kingston. First of all, the Attorney General has begun the process of appealing. The process to appeal a decision from the full court to the Court of Appeal, which is the court to which an appeal lies, is to first get leave of the Court of Appeal to file the appeal. An application has already been made to the Court of Appeal seeking leave of that court to file the appeal against the decision of the full court. It is my respectful view that the full court fell into error. It is my respectful view that the decision is wrong in law and that the decision must be appealed. And if so, the appeal will travel all the way to the Caribbean Court of Justice for final resolution. This is a case where the state vested a very expensive piece of real estate into one of the government's holding companies, of which the government is the exclusive and sole shareholder. That company decided to sell the government's property, which the government passed to that company. That company decided to sell that property, valued approximately 8 billion Guyana dollars for 200 million Guyana dollars, and accepted from the purchaser 100 million Guyana dollars, although the purchase price is 200 million, which is a fraction of what the value of the property is. The property is valued about 8 billion. It was sold for 200 million. 100 million was received, and a free title passed, free from all encumbrance. And the title says that it was passed free from any outstanding monies owed. In other words, the buyer gets a clean title for paying half of the agreed purchase price, which is only a fraction of what the value of the property is. And when the Attorney General, who represents the government, sues because the government feels that it has been defrauded its property, the courts are telling the Attorney General and the government that the Attorney General and the government is meddling or are meddlers. Imagine government property being sold recklessly, negligently, fraudulently, and when the government goes to the court to say, look, my property is being sold or has been sold fraudulently for a minute fraction of its real value, the court tells the government, you are meddling. I don't know by what principle of law that is justifiable. I don't know. Let me stop there, and the matter will be pursued to the very end. This case reminds me of the case that I filed to challenge the appointment of James Patterson as the chairman of GCOM. The High Court told me I have no case. The Court of Appeal told me I have no case. And when I went to the CCJ did not even want to hear me, but ruled in my favor. They said on the record that they did not care to hear legal submissions. It was such a clear case. But I have to travel the road, and the government is committed to traveling that road. This is a government company. It's not a company that bought property from the government. It's a company that was gifted property by the government to hold. The company is not in the category of a regular company that can dispose of its assets. The government, by law, under the Public Corporations Act retains a power through the Minister of Finance to dispose of that property. The Minister of Finance, at the time Winston Jordan, decided to dispose of the property without his own government's consent and or authorization. There was no cabinet decision authorizing Jordan to act. Even in his own government, the government, in my respectful view, has every right to sue the company, the directors, the Minister of Finance, as well as the person who bought. Here, the court is not even hearing the government. The government has not been allowed to put forward its case yet. The court is telling the government that it's a meddler and strikes out the case without even hearing the case. As I said, the appeal will travel the long journey to the Caribbean Court of Justice. Please continue to share the program so that we have the widest possible audience. Continue to comment. And if you wish, you can comment on the matters that I am speaking on or comment on matters that are relevant. I am not going to engage in what I consider to be irrelevant or improper issues. I'm going to comment on matters that I am speaking on or matters that I consider relevant. I see today in the newspapers Mr. Paul Slow attempting to drag me again into some type of discourse about whether Nigel Hoppy was appointed to act in the office of Commissioner of Police or not. Paul Slow maintains in his letters in the papers that Nigel Hoppy was not appointed to act. Well, Paul Slow can continue to hold that view. The Chief Justice of the country, Roxanne George, has ruled that Hoppy's appointment to the post of Commissioner of Police acting was unconstitutional. And the Attorney General has expressed the very view. I have neither the time, the energy, nor the inclination to engage Paul Slow on matters that are way beyond his competence and the comprehension. And I say so with the greatest of respect. So he can continue to maintain whatever position he wishes. I will not be dragged into any discourse with a person who is not qualified and competent to engage in such a discourse. So, I have spoken a lot about a modern arbitration bill. The bill is now ready. It is now ready and will be taken to the National Assembly. Of course, once it receives the approval of Cabinet when Parliament resumes. The bill is considered to be, well, it was extracted from a model bill of the Caribbean. However, we have added significant dimensions to it. Most importantly, it has received the benefit of reviews from international law firms such as Arnold and Porter and Gibson and Dunn of the United States of America. In addition, Gibson and Dunn conducted workshops in Guyana on arbitration. The state lawyers and lawyers in private practice and even lawyers in the private sector attended the arbitration sessions. Impact Justice also did a series of training workshops on arbitration in Guyana, all based on this bill. This bill was first drafted as a model legislation for the Caribbean by the very Impact Justice. But we have improved upon it. We have added components to it that make it different from the model bill. I have often said that this bill, once it passed into law, will form the foundation for commercial and domestic arbitration to be done in Guyana. It has, as part of the bill, what is called the UNCITRAL rules, which is the international gold standard rules regarding arbitration. This bill also permits international arbitral companies or companies that are offering arbitration services to locate in Guyana and operate under the bill. It allows for judiciary-driven arbitration, as well as it allows for parties to decide between or among themselves to take their dispute for resolution by arbitration utilizing the law. It will permit international arbitration companies operating in the arbitration capitals of the world to come to Guyana to do arbitration if they wish. Hopefully, we will be able to persuade companies executing contracts in Guyana or with Guyana or Guyanese companies to choose Guyana as the seat for the settlement of disputes by arbitration. Many of the international agreements, many of the important commercial agreements that are being executed now in Guyana or in respect of operations taking place in Guyana contain arbitration clauses as the desired mechanism of settling disputes. But the seat of those arbitration are outside of Guyana. This bill, once it becomes law, hopefully will influence companies to change that approach and situate Guyana or identify Guyana as the seat to do their arbitration. It will bring a lot of international dispute resolutions to these shores. It will bring a lot of revenue to these shores. It will bring a lot of employment to Guyanese. And of course, once the arbitration takes place here, all the monies expended in relation thereto are going to be done here. International arbitrators will have to come, they will have to stay at hotels, witnesses will have to come, they will have to stay at hotels. So Guyana is going to be benefiting from almost every conceivable perspective. It is the hope that once we can make Guyana self-sufficient in terms of arbitration, then we would move to the second stage and refine the process and the infrastructure to such an extent that we will be attractive or an attractive destination for arbitration in relation to the Caribbean, Latin America, and even South America. And this bill will lay the foundation for that. A lot of work has gone into it, and it is now completed. The Attorney General Chambers will send it out one last time to important stakeholders for their input, and then it is going to go to Cabinet for consideration and then to Parliament. We will continue training exercises in the area of commercial arbitration in particular. Hopefully, I've begun to speak to the University of Guyana, and I want to encourage, and I'm encouraging the University of Guyana to include commercial arbitration as one of their courses in the Bachelor of Laws degree program. So we will get a sound grounding very early in the area of arbitration law. The truth of the matter is, more and more companies across the globe are choosing arbitration as the preferred method of resolving their commercial disputes. So whether they want to go to the court, we are building an efficient judicial system. If they want to go to arbitration, we are building an efficient, modern arbitration system as well. The first step in that direction is to get the law right. And I believe, respectfully, that we have the law here. We now have to begin the educational process. So we have an educated and a qualified population to serve the sector. And where best to start than the university itself that will be graduating the lawyers and those who wish to be academically trained in the area of arbitration. And that brings me straight to the law school. It is now public knowledge that the Council of Legal Education has given Guyana permission to begin to work on the establishment of a local law school under the auspices of the Council of Legal Education of the West Indies. Work has begun on this important initiative. At the level of the government, a committee has been established which yours truly chairs. That committee includes persons from within the government, persons from the private sector, as well as persons from the University of Guyana. It has already been decided at the level of the committee and, of course, the government of Guyana that the law school will be located at Turkine campus of the University of Guyana on, I believe, a 5-acre plot of land that will be dedicated to that purpose. Members of the committee have already written to, the Council of Legal Education has asked Guyana to do a feasibility study to demonstrate the viability of such an institution in Guyana, and work has begun on that feasibility study. Information has been requested from the University of Guyana and all the law schools in the Caribbean, as well as all the universities in the Caribbean and learning centers that do the Bachelor of Laws degree. And those statistics are being compiled for the purpose of the feasibility study. I believe the intent is to get the numbers of persons who are studying law, who have LLB degrees but have been unable to get into one of the regional law schools. So how many persons are out there? What is the market like? Etc., etc. All of that information is being gathered. Members of the committee have also been traveling to the law schools in the region and gathering information that they are using to prepare the feasibility study. Recently, last month, I was in Jamaica to attend a Council of Legal Education meeting, and I took the opportunity of updating the Council of Legal Education on the progress that we are making in this regard. So, we are getting closer to the realization of that dream to make Guyana the home of a regional law school. In fact, the broader vision is to make Guyana an education destination. Bringing the law school here is only one step in that direction. But more will be said about how we will work to achieve that grand objective. You may have heard me say before that we are currently working to revise the laws of Guyana. Revision of the laws of Guyana entails inserting into the laws all the new laws that we are passing and inserting into the principal acts or legislation all the amendments that are being passed in the parliament. So remember, at any given time, you have a bundle of laws that are being passed but are not in the formal volumes of the laws. And that happens in any country. So at periodic intervals, countries have to engage in what is called a law revision exercise, where they insert into their laws all the different pieces of legislation that would have been passed over a period of time, so that the laws become consolidated and you can find all the laws into volumes. For the purpose of those who may not know, there was a great hiatus in Guyana in relation to law revision. One law revision exercise was done in 1977, and another one was not done until 2012. So that purple book, which is the Laws of Guyana, was done in 2012, and its predecessor was done in 1977. So you see a massive gap there. When the 2012 exercise was completed, there were certain errors, there were certain omissions, etc., simply because of the volume and magnitude of the task at hand. We waited too long. I completed that process in 2012 as Attorney General. It started under my predecessors, I believe Mr. Dudnath Singh and then Charles Ramson, and I concluded the exercise. This law revision that we are now completing another set of law revision from 2012 to 2022. It was budgeted for in my ministry's budget this year, and I'm pleased to report that the exercise is now being concluded. The covers are being acquired from the United States of America, from a very reputable company producing covers for many states in the United States, covers for the laws of many states in the United States. So it's a quality company. The covers are a little expensive, but you have to pay for quality. And the exercise is being done at the Law Revision Center of the Caribbean, which is located in Anguilla. It is expected, and I've been promised, that we will get the final set before the end of the year. And then, of course, we have to bring them to Guyana and replicate them. Currently, there are 14 volumes of the Laws of Guyana, but when this exercise is concluded, those 14 volumes will increase to 28 volumes. And we will be printing 200 sets of those 28 volumes. So you see how many laws we are passing? We have moved from 14 volumes of the laws to 28 volumes of the laws. And we plan to print, or we have budgeted to print 200 sets of the volumes. Of course, that's the hard copies. We are going to have soft copies done as well, which will be made accessible. It is a critical achievement for a country's laws, to be updated and accessible. And that is what we are doing. When we speak about modernizing Guyana, that is part and parcel of modernizing the country, where you can go on the computer and you can get an updated version of the country's laws. In this case, our laws, when this exercise is completed, is going to be updated up to December 31st, 2022. Just last year, December. That is the type of work that is being done. It's difficult to put value or money value to these types of initiatives and exercises. But that is what your government is doing. And these are not glamorous work. This is back-breaking work being done in the back rooms. Every piece of legislation we have to find and send it. We have to format it and then send it. And then you have to work with the people to proofread it. Then you have regulations that have to go with it. It's not easy work. We are also going to conclude this year the law reports. And for those who may not know, the law reports of a country contains the important cases that would have been decided by the courts of that country. They are recorded and kept in volumes, so that when a similar case comes up, a lawyer or a judge or a law student can go to those volumes and pick it up and use that case to persuade the judge to rule in the manner that the case says they should rule. Remember, law in our system is based upon precedent. So if a case was decided on a particular set of facts, and there's a written judgment, and a case of similar factual matrix arises in the future, you can use the decided case to influence that court to follow this decision. In fact, if it is a decision of a higher court, normally the lower court, if that case is before a lower court, the lower court is bound to follow the decision of the higher court by what is called the doctrine of judicial precedent under the rules of stare decisis. I don't want to get too technical, but that is how it is done. So when you have these law reports organized like that, and the cases are in there, then it makes judicial decision making very easy and very consistent. The last time these reports were done was in 2008. And it was done between 1977 and 2007, 1977 to 2007. Again, it was done whilst yours truly was Attorney General. But other people were working before me to get it done. Now I am doing from 2008 to 2021. So from 2008 to 2021, all the important decided cases are now going to be put into yearly law reports. So 2008 will have the 2008 cases, 2009, 2009 cases, and you go on until you reach 2021. Again, one had to go and find those cases and then get people to read each one, brief them, and put them into reports. This exercise is being done by an agency in Barbados, and we are paying that agency to do the work. We got a lot of funding. We got a lot of financial assistance from Impact Justice, a Canadian-funded project being executed at Cave Hill campus in Barbados. And Professor Vilma Newton has been instrumental in assisting Guyana in executing this exercise. And I want to thank her publicly on this program for the work and assistance that she has done and assistance that she has offered. Tremendous person. That initiative is also expected to be concluded by the end of this year, hopefully. If either of these go over, it will not go over by much. Go over to the new year, it will not go over. We are pushing hard to get them concluded by December 31st of 2023. Again, I pause to recognize the efforts of so many public servants who are working on these initiatives quietly in their own corner. Quietly in their own corner. This is not glamorous work. This is very tedious and time-consuming work. But it is work that our government is committed to doing, and we are doing it. These are initiatives and things that have never been done in Guyana on a regular basis. I told you the gaps from 1977 to 2012 in relation to the laws. In relation to the law reports, 1977 to 2007. Both are being brought up to speed now. The laws up to 2022, December 31st, and the law reports December 31st, 2021. These are remarkable accomplishments. So let me read some of your comments, and please continue to share this program so that as many of the persons on your page and on your account will be viewing. You have some people who are coming to distract you from this program. People like Mark Abrams, and so you ignore those people. You don't engage them. Those are people who still tell you that they APNU AFC won the elections. Those are people who still tell you that APNU AFC won those elections and that the PPP rigged those elections. From the time a person puts that on Facebook or says that anywhere, I write that person off as either insane or delusional. You don't bother with people like that. I call them the Kool-Aid gang. They are so gullible that anything they would believe, or they're simply too stupid to bother with. So don't engage those people. Let them go ahead and think that they won the elections. There can't be sensible people. So once I see a person say that, I'm done with them. I already make an assessment of their mentality, and I don't take them on anymore. They're crazy. And you can't bother with crazy people because, you know, they say if you argue with a man who is insane, a bystander may not know which one of you is insane. A person who don't know that the man is mad and hear you arguing might end up thinking that you mad too. So when you hear people like that, you don't bother with them. Let them go ahead thinking that. They only irritate you. I also want to use this opportunity to give an update on the Special Prosecutors Program, which the Ministry of Legal Affairs launched about 2 years ago. You will recall, for the record, that we have had in Guyana dozens of persons who completed Bachelor of Laws degree but could not and did not travel to complete their certificate of legal education at the law schools for whatever reasons. Remember, the law school, Ewing Law School, that's a law school to which we are zoned, only accept, I think, 25 persons per year. So when you have a class of 40, you have 15 persons who would have graduated but can't get into the Ewing Law School, so they are left here. So we have police prosecutors prosecuting in the magistrates' courts across the country. And all of you, whoever went to a magistrate's court, will see that there's a lawyer on one side appearing for the defendant, and the virtual complainant is represented by a police. Now, a police have a certain level of education, they have a certain level of training, they have a certain level of competence. Now, and with that, I would say, and I have said it publicly, that the police would have done an excellent job in prosecuting. Police have to face big, reputable lawyers, and they have been able to acquit themselves with distinction prosecuting. And they continue to do so, I dare say, with distinction. But I thought that if we add all these people who have LLB degrees, we bring them together and we train them, give them further training in prosecution, and put them among the police in the magistrates' court across the country, then we must be able to make a difference. Because at the end of the day, the prosecutor represents the victims of crime. They represent the state. They represent the public interest. And you want you want the scales of justice to be as balanced as possible. So, I brought together these prosecutors and we arranged a program to train them at the University of Guyana. A program where the DPP lectured, the many lawyers in private practice lectured, I believe the Chief Justice lectured, many judges in the High Court lectured, and a program was specifically done to train these people, these LLB holders, to further train them in practice, in procedure, in evidence, and to prepare them for prosecution. And we have now graduated one set, 29 of whom are already in the system working. They have already joined the ranks of the police, and they are working with the police in various magistrates' courts across the country. They are in regions 3, 4, 5, 6, and 10. They are in regions 3, 4, 5, 6, and 10. Now, expectedly, we encountered some teething problems. This is a new initiative, never tried anywhere before. And we have tried it, and we are succeeding. This is a model program that Caribbean countries would like to emulate. We started it in Guyana. We are the only country in the entire Caribbean where you have these persons, where you have LLB practitioners prosecuting in the magistrates' courts. None of the countries can afford to send lawyers to prosecute all the cases. Even in Guyana, we used to send, only in high-profile cases, you send a lawyer to prosecute. The rest of the Caribbean is the same thing. They send police prosecutors. Here we have police prosecutors now being ably assisted by persons who are almost lawyers. The quality must improve. We have 29 of them in the system currently working, and we are adding 9 more who are now completing another course of training. 9 more, so we will have 29 and 9, 38 very shortly in the system. And I think that that's another remarkable accomplishment. If we don't speak about these things, nobody will speak about them. And this is not blowing our own trumpet. This is telling you what we are doing to transform this country. This is not pointing to highways and bridges and roads and edifices. These are things that you are not going to see. They're not spectacular to look at. They may not even be tangible. So if we don't talk about it, you don't know. And that's why I decided to spend some time to talk about these landmark programs that are taking place in Guyana, all intended to create a better society for the people of our country. Some of these initiatives are not even in the third world, in the first world happening. They're not happening there. They're happening right here in Guyana. You would never hear this from the opposition. You would not even hear a compliment. Many of them are lawyers. They go in the court. Almost every court in this country is now air conditioned. Almost every courthouse in Guyana is air conditioned. You would never hear a compliment from any one of the lawyers. And they were air conditioned under our government. Let me hasten to say that. They were air conditioned under PPP's government. And that's a simple thing. I'm not making that a big issue. To me, that's not a major accomplishment. But it's a transformation from what existed before. But you think you will ever hear Comrade Ramjatan or Roysdale Ford or any one of them pay a compliment to the government? Saying that they speak through microphone in the courts. Their evidence is automatically recorded. Their presentations, their submissions are automatically recorded. They can get transcripts generated within 24 hours. All of that in the court system, in the justice system today. As Attorney General, the PPP government made all of that possible. It happened during my tenure as Attorney General. I brought in the first auto recording system, voice recording system from the United States of America and put it in the court system in this country. If you don't talk about it, nobody will talk this story for you. I don't like to blow my own trumpet, but the trumpet has to be blown. And if nobody blows it, it will never be blown. So as I said, today I will deal only with my sector. So there are a series of bills that are ready to go to the National Assembly when Parliament resumes sitting. I spoke already about the arbitration bill. A brand new plea bargaining bill is ready. This bill will allow for the prosecutor and the defense counsel to negotiate a position long before the matter reaches the court. And they can go to court simply to tell the judge what they have arrived at. Of course, it must be done in accordance with law. This happens all over the world, and it eases the backlog and it eases the burden on the court system. So the two parties can meet. If the accused decides to change his plea and plead guilty for manslaughter, the DPP and the defense counsel can work that out and go to the court and report it. And that can be done in 10 minutes, and the court can do another case. That is what the plea bargaining bill allows. And it brings in all the relevant persons. So not everything you have to go to the court for. You can simply go to report that you have used the plea bargaining and the man will accept 5 years. And you don't have to do it in front of the court. Both parties sign their plea agreement and you take it to the court and you enter it. It brings speed and effective disposal of cases. And this is happening all over the world. We are late in implementing this. The next one is the paper committal bill, where we are abolishing PIs completely. So preliminary inquiries are going to be abolished. And we are doing, you go before the magistrate, the two sides present their statements, the magistrate decides whether he will commit or not. The preliminary inquiry now takes years in the magistrate's court. This paper committal can take a few days. Once all the statements are done, the magistrate reads them and I suppose hears submissions from both sides and decides whether he will commit or not. Of course, we have to ensure that we have enough judges now in the High Court, because after all the PIs are going to be dispensed with in the magistrate's court with great speed, not all of them will be dismissed. Many committals now will take place, and a long queue will accumulate at the High Court. So we have to ensure that we have enough High Court judges who will be able to dispose of the long line of cases. It makes no sense transfer the load from the magistrate's court onto the High Court. We have to have a system that fluidly disposes of them. So the plea bargaining is one mechanism. The paper committal bill is another one. So this is also ready. The Family Violence Bill, I've spoken a lot about that. That will repeal the Domestic Violence Act of 1997. And this is a modern family violence bill that is both criminal and civil. The Domestic Violence Act is civil only. This one it's modern, it has far wider amplitude. It deals with wide-ranging factual situations. It gives a lot of additional powers to the police, etc., and the magistrates. So that bill is also ready. We have sentencing guidelines that is drafted and is with the judiciary. Our consultant, the consultant attached to legal affairs that was hired to do this job, completed the first draft and is required to send it to the judiciary, and it is there awaiting the input of the judiciary. Remember, sentencing guidelines is intended to bring consistency to sentences. Many a times I read in the public domain criticisms in relation to sentencing. Some people complain about inconsistent sentencing. Some people complain about excessive sentencing. Some people complain about lenient sentences. Here you have sentencing guidelines, and you will have sentencing hearings under these guidelines. So you can pick up the sentencing guidelines and you can know what sentences are likely to be imposed for what offenses and what are the principles that a judge must follow when imposing sentences. So there is transparency, there is accountability, there is rationale in decision making. So decision making doesn't appear to be arbitrary and capricious, but it must now be based on principles and reasons. And sentencing guidelines are going to be made public. These are public documents. You can get a copy. My operator is signaling to me that I have passed program time, so I will continue this discourse perhaps next Tuesday as I continue to update you on the progress and programs of the Legal Affairs Ministry. I think I will continue this because we have so much to discuss in my ministry alone. I decided not to talk much politics tonight, but to give you an update on the work that is being done in the Legal Affairs Ministry and in the Attorney General Chambers. I want to thank you very much for the time that you have spent with me. We have been speaking for nearly over an hour, and I believe that we have covered great depth and breadth, and I would have given you a comprehensive update on the work being done by our government and in particular by the Ministry of Legal Affairs and Attorney General Chambers. Thank you very much. Enjoy the rest of the evening and stay safe until I see you next week. Thank you and goodbye.